Today, the leader of our nation showed in his latest public outing that he lacks the mental and emotional strength needed to carry out his duties under the Constitution. There's simply no working sense of reason or sound decision-making in the person who holds that office right now. And remember, this same individual controls the codes that could end life as we know it on Earth. Donald Trump is in a complete rage at this moment because a federal judge named Marianne Keller has just mandated the prompt release of a huge collection of proof that his attorneys battled hard to keep locked away for a long time. This goes beyond a standard file dump. We're talking about records of confidential discussions revealing his actual words, banking details tracking fund movements, and inside messages that supposedly point to unlawful commands he issued to his staff. All of it is hitting the open air as we speak, but the real sting comes from how it unfolded. The judge didn't just hand down a low-key document that his legal crew could challenge through appeals. Instead, she delivered her full decision verbally in a public courtroom with cameras rolling. She laid out in detail why each of Trump's pleas for confidentiality fell short. She stated plainly that citizens deserve access to this information. She dismissed worries about disrupting active probes. She turned down ideas about biased harm, and she demanded the full reveal happen right away without any holdups. Trump's attorneys were stuck there absorbing it all. They had to hear the judge tear apart their every point in front of everyone. This marks a crushing blow in court that lays bare Trump's whole approach to hiding things as a total flop. Now that material he aimed to bury for good is out in the open, getting picked apart by officials and legal teams hunting for wrongdoing. Trump realizes this might ruin him in the courts. Folks in the Capitol get it, too. And if you're looking to keep up with the big stories, hit that subscribe button. It really counts for us. That's the reason we created The John Brown Show, to deliver honest accounts with real background. Okay, let's dive into the details of what went down. The decision to open these files includes a wide range of items Trump spent ages trying to shield. Records from closed-door talks among him and his close advisors. Money trails exposing deals he preferred to conceal. Private exchanges like electronic notes, phone messages, and reports all pouring out to the world at this instant. Judge Keller determined that the benefit to society from making this known trumped any personal stake Trump had in secrecy, and he's going ballistic, firing off angry posts on his social platform, labeling it a court-led persecution, and going after Judge Keller herself. Yet this isn't some targeted chase. It's a judge in the federal system upholding rules of openness. She examined his reasons for privacy, deemed them weak, and called for the reveal since people should understand their leader's actions. The judge reviewed the stuff Trump sought to stash and declared that everyday Americans ought to view it. Pass this along to your contacts, because each time Trump blasts Judge Keller for pushing openness, it just proves he's guarding something harmful. He's building a loop that feeds on itself, heightening how suspicious he appears and speeding up his troubles in the law as it plays out. Now, allow me to pull out the key facts on why this decision hit so hard and left Trump with no way out. By voicing the ruling right there in the courtroom, Judge Keller had options. She could have put it in writing. His group would have gone over it privately and geared up for challenges, but she opted to speak it out loud, crafting a scene in the court that got recorded and spread far and wide, ensuring all grasped precisely why his bids for secrecy didn't hold up. Consider the impact. When your case crumbles so thoroughly that a judge announces the dismissal verbally in session for the widest possible notice, you've been defeated outright. The judge turned his loss into something everyone could see and accept as fact. Speaking it out broadcast a signal to lawyers everywhere. Trump's methods for keeping things under wraps are done. Judicial systems are leaning toward clarity. The greater good overrides individual wishes to conceal proof. When a judge at this level openly dismisses Trump's privacy pleas, it gives others the confidence to follow suit. And that's unfolding right now. A trend is taking shape in various lawsuits. Courts are turning away his efforts to lock away proof, mandating releases because they recognize what Judge Keller did. His points are geared towards self-P protection meant to dodge responsibility instead of meeting true needs. Look at the controversies these opened files supposedly tie into. They're many and severe, weaving together to paint an even darker scene for Trump to start possible wrongful orders. messages that reportedly indicate he told underlings to do things against the rules. This isn't about differing views on policy. If confirmed, it's outright plotting to break laws. Next, links to the events of January 6th, files that supposedly cover attempts to handle the aftermath of the assault on the Capitol. What he was aware of, his responses, and how his people worked to mask his involvement. Then issues with money handling, documents that reportedly reveal transfers and deals that cross legal lines, funds ending up where they shouldn't, signs of graft or personal gain, plus blocking justice, exchanges that supposedly depict him and his circle talking about stashing away proof, aligning their accounts, and deceiving those looking into it. Put together, these sketch a leader who time and again ignored rules, wielded authority for his own ends, and then aimed to erase the tracks. Be certain to subscribe to The John Brown Show because on top of that, the swift timeline for opening everything leaves Trump no room to manage the fallout. Sometimes judges roll out releases slowly with pauses for challenges spread over weeks or more. Judge Keller called for instant access, all of it available immediately. No last-minute blocks, no rushing to sympathetic courts, no chance for his side to craft the story. The whole batch lands in view at the same time. This is a current head of state seeing proof he resisted for years get exposed in one go. Nothing like this has occurred in our country's past. Additionally, the spoken delivery forms a lasting mark. The courtroom event caught on video. The judge's explanations of why his claims didn't stick that enters the books of history, shaping how this term in office is recalled. Moreover, it sets a benchmark for future matters. Other judges can refer to this decision, quote it when he raises similar privacy points in different spots. A standard is solidifying that he can't shield proof any longer. Now let's discuss the specifics of what got released, what it reportedly reveals, and why this poses such a major risk to him, both in law and politics. The records from those confidential sessions expose his real statements when he believed no one outside was hearing. In such gatherings, folks let down their guards, express true thoughts, and outline plans. These reportedly clash with what he said openly. They indicate he recognized his steps were improper. They show awareness of likely offenses. You can't deny uttering words when the log confirms it. You can't alter the past when your statements are on record. Pass this to others because the banking details provide hard facts on cash flows. Not his assertions, not his lawyers' debates. The true paths of the deals. They reportedly highlight payouts that break rules, washing funds, payoffs, personal enrichment. You might twist language, but you can't dispute ledgers that track money to forbidden destinations. The private exchanges illustrate choices as they occurred. Who was informed at what point? Who issued commands? Who flagged legal worries? They reportedly confirm he steered toward unlawful steps, confirm he grasped that his actions were off base. That's proof of bad intent captured in his messages and notes. Observe what the supposed wrongful command suggests. If accurate, him directing staff to violate statutes. That's joint scheming. Every command might stand as its own accusation. Each person who followed through could testify against him. The count of possible offenses grows with each file displaying improper guidance. Ensure you're following us because this is straightforward proof of illegal behavior, not based on hints or assumptions. His own language reportedly calling for offenses. The items tied to January 6th are especially harmful. Files that reportedly indicate he was aware the assault was underway, comprehended the breakdowns in protection, took no action to halt the chaos, and later sought to obscure his part. That's neglect of responsibility combined with interference. Several violations from one episode. The handling of consequences messages reportedly show teamwork. Him and his group debating how to frame the tale, if they should eliminate proof, what to share with probers. That's admission of fault. Interference logged as it unfolded. Now permit me to guide you through the reasons this has such weighty effects on his other active lawsuits. The open proof can apply broadly. Criminal cases can pull from these files. Private suits can draw on them. Legislative reviews can demand accounts related to them. It all builds up. A single release sparks issues across all his battlegrounds in court. Legal teams in various areas now hold proof they lacked prior. Each discovery ties into their pursuits. Money trails hinting at offenses in New York. Messages pointing to blocking in national matters. January 6th, details for Capitol Hill probes. The session logs pin him to stances he can't wriggle from. Should he speak under oath anywhere, he must account for his private remarks. Align the mismatches. Any slip turns into a lying charge hazard. The files lay snares he can't sidestep. Pass this video along because the money logs launch trails that investigators will trace for a while. Begin with one odd deal. Chase the path. Uncover additional ones. Construct evidence of ongoing graft. A single entry branches to many. The exchanges establish awareness and purpose. Demonstrate he knew steps might be against rules. Talked it over with others. Went ahead regardless. That's precisely the element legal teams require for accusations. Members of his top team are said to be examining the released items. Some reportedly voicing worries over what they disclose about his behavior, about if he can keep serving. These are rare responses within his own circle. The reality that those nearest to him doubt his suitability underscores the harm from this exposed material. The strategic thinking driving his heated backlash is straightforward and harsh. These files shatter his protections, oppose his open declarations, supply grounds for numerous likely offenses. He understands that if this gets fully examined and grasped, he's in deep trouble with the law. He knows officials will employ it. Lawmakers will dig in. Rivals will use it against him. So he's choosing a deliberate path. Target the judge, target the system, attempt to undermine the release by terming it a pursuit. Then he can claim to backers afterward that the proof is irrelevant since it came out wrongly. It's not very successful. The files are public anyway, but he's pressing on. And when he begins slamming judges in the open, things intensify more, generating extra court troubles, further signs of blocking and pressuring those involved. That's what we're witnessing, him breaking down, lashing out at all, worsening the mess. Hit subscribe because here's what these release mandates truly signify for his path ahead. He's confronting the gravest reveal of proof since the probe started. Items he resisted for ages to conceal turning public isn't minor or overlookable. This isn't a few messages pulled without background. It's a full set. Session logs, money trails, exchanges, the works. When that volume hits the light, it builds huge strain, influences all aspects, shapes how officials weigh charges, how courts assess his points, how folks see his fault, how others choose to help out. All of it. He can brand it a pursuit. Endlessly. It doesn't alter that a federal judge mandated this public, judged his privacy pleas lacking, and decided openness prevails. In summary, Trump is utterly enraged. Judge Keller has directed the swift opening of a vast trove of proof logs from confidential talks, money details, private messages that reportedly expose unlawful commands. He believed he'd keep it hidden forever. The judge avoided a subtle written directive. She spoke her whole decision in session, recorded, detailing why each privacy plea collapsed, affirmed citizens' access rights, brushed off active probe disruptions, dismissed bias harm notions, called for instant opening, no pauses. His attorneys endured it there, heard her dismantle their case publicly, a disastrous setback that uncovers his hiding plan as an utter miss. The material now open for review by probers and officials seeking violations. He's unraveling, blasting angry messages on his site, deeming it a court. Persecution, hitting Keller directly, but it's no such thing. A judge enforcing openness standards, reviewed pleas, found them short, mandated reveals since people merit knowledge, examined the material, said Americans deserve to view it. Each assault just affirms he's concealing harm. A cycle that builds on itself, appearing more at fault, rushing his court risks in the moment. Voicing it out made it crushing and unavoidable. She could have written it. His crew would review in private plot challenges, but she picked public speech. A court event recorded, shared broadly. All comprehended why pleas failed. To falter that badly with her announcing the denial allowed for peak notice means total loss. Rendered the setback clear and irrefutable. Delivered a note to legal circles. Hiding strategies fail. Systems favor clarity. Societal good tops personal concealment. A judge of this stature openly turning down empowers peers to match. That's occurring, a shift across lawsuits, denying lockup bids, calling for opens because they spot what she did. Points are self-focused to evade blame over real aims. The opened items linked to many harsh issues, wrongful commands, messages reportedly showing he told staff illegal steps, plotting, if true. January 6th, reportedly handling Capitol assault aftermath. His knowledge actions cover attempts by Team Money wrongs, logs reportedly of illegal deals, funds misplaced, graft self. Gain blocking talks reportedly on concealing proof story alignment, misleading probers combined. They depict a chief who often defied laws, applied power for self-sought to bury it. The quick opening offers no fallout. Prep courts at times phase releases with challenge gaps over time. She demanded now all out instantly. No urgent blocks, no ally courts, no story-shaping window. Proof floods at once. A serving leader's long-fought secrets exposed together. Unprecedented in our history. The verbal share creates enduring mark. Session on video. Her explanations of failures in history's pages shaping term recall. Benchmark for others. Judges can cite use when similar arise. Shift firming. He can't conceal more. Logs reveal true words in supposed privacy. Such talks drop pretense. Real views, schemes, reportedly oppose public words, show awareness of wrongs, crime sense, can't deny speech when record shows, can't revise with documented talk, money logs, firm proof of flows, not claims, not debates, real deals, reportedly illegal payouts, fund cleaning, payoffs, enrichment, twist talk, not bank tracks to wrong spots, private shares, choices, live knowledge, timelines, commands, legal flags, reportedly confirm illegal steering, wrong grasp, intent in messages, wrong commands if true, directing law breaks, plotting, each a charge. Followers as witnesses, crime stack per file of bad guidance, straight proof of wrongs, not hinted. His words calling for them. January 6th, items hurt most. Reportedly awareness of assault, security lapses, no halt, later cover, duty fail plus block, multi-offenses, one event. Aftermath handling, reportedly team talks on tail framing, proof wipe, prober stories, guilt sense, block logged, live court effects, big for other cases. Proof usable, wide prosecutions, pull suits, note probes, call witnesses. Builds one open troubles, all fronts officials in areas gain unseen proof, finds link cases. Money crimes, New York block federal. January 6th, Congress logs fixed stances, inescapable oath talk, explain private words, match gaps, mismatch, lie risk traps, unavoidable money logs, start probe lines, months-long odd deal chase, more fines, pattern graft, one-to-many shares, prove know-how, aim, grasped illegal potential. Associate talks preceded what accusers need, top aides reportedly scan items, some worry over reveals behavior service fitness, rare inside responses nearest doubting. Shows proof harm, backlash, math, simple harsh files, break shields, clash, public licks, ground, multi-crimes. Nose exam means deep risk officials employ lawmakers, dig foes, use choice, hit judge system, undermined by pursuit label. Tell fans proof invalid, wrong release weak, but files out he does. Public judge hits, escalate more troubles, block signs, pressure scene breakdown. All attacks worse, making police's mean ahead. Worst proof show since start. Long hidden public, not minor. Full trove, logs, money shares all. Volume builds pressure, touches all. Charge calcs, argument views. Guilt sees witness helps everything. Pursuit call changes nil. Judge mandated public, pleas weak. Openness rules. This tale goes on. Keep watching.